Imagine waking up every morning to the same sound. Not your alarm, not traffic, not something you can control. It's not coming from inside your house. It's coming from your neighbour's roof. At first you tell yourself it's nothing. Rain happens. Water moves. You live around other people. This is what living in a city is like. But then the sound doesn't stop. And then you notice the wall. And then you notice the stains. And then, slowly, almost insultingly slowly, you realise that the damage is accumulating. Not dramatically, not all at once, but in the quiet way problems usually do when they expect you to tolerate them. In ancient Rome, one man decided that this wasn't just annoying, it was illegal. So he did something that feels shockingly modern. He sued. History is usually told through wars, emperors, and grand events. But today we're looking at something smaller, something familiar, stories that prove humans have never really changed. This is Same Old Humans. This story is not about water. It sounds like it is. That's the trap. Rainwater, roofs, drainage, dripping, minor inconvenience. If you describe this case in one sentence, it sounds petty. And that's why it's tempting to treat it like a joke, the ancient equivalent of someone calling the police because their neighbour's tree is shedding leaves into their yard. But this story survives because it wasn't trivial. It survives because it sat right at the intersection of three things Romans cared deeply about: property, responsibility, and proximity. Water just happened to be the medium. To understand why this became a legal problem, you have to forget modern cities. Roman cities were dense in a way that modern zoning laws are specifically designed to prevent. Buildings pressed against each other. Walls were shared. Roof lines overlapped. Streets were narrow, dark, and loud. Privacy wasn't a right. It was an accident. If your neighbour built something new, you didn't just notice. You felt it. Literally. Structurally. Sometimes financially. This wasn't suburban living with polite fences and distance buffers. This was urban compression. Everyone was in everyone else's space all the time, which meant that what your neighbour did to his property rarely stayed his problem. Rainwater doesn't respect ownership. It follows gravity. That's it. In a tightly packed city, gravity becomes political. If water flows the way it always has, no one complains. It's natural. It's expected. It's inconvenient in the way life is inconvenient. But once someone modifies their building, changes a roofline, adds a drain, redirects runoff, water stops being natural and starts being deliberate. And once something becomes deliberate, blame enters the conversation. This is where irritation turns into resentment. Not immediately, slowly, over time, with every rainfall. No one wakes up wanting to sue their neighbour. That's not how disputes like this start. They start with tolerance. You tell yourself it's not worth the trouble. You convince yourself it'll dry out. You assume the damage won't be serious. You don't want to be that person. Then the stains appear. Then the plaster softens. Then the repairs start costing money. And at some point, usually later than it should, you realise something important. You are paying for someone else's decision. That's the moment everything changes. Not emotionally, conceptually. There's another part of this escalation that never shows up in legal records, but everyone recognises immediately. The part where you delay. You don't want to be unreasonable. You don't want to overreact. You don't want to look petty over something that might, eventually, stop on its own. So you wait. You tell yourself you'll bring it up if it gets worse. You tell yourself the next rainstorm will be lighter. You tell yourself that this is just one of those annoyances you accept when you live near other people. And the longer you wait, the harder it becomes to say something. Because now you're not just complaining. You're admitting that you've been silently tolerating a problem for weeks, maybe months, while the damage slowly accumulated. At some point, the conversation you should have had early feels impossible to have late. That's when people stop talking to each other and start thinking about systems instead. Not because they love rules, but because rules don't require awkward conversations, raised voices, or the uncomfortable realization that your neighbor may simply not care. By the time someone in Rome took a rainwater dispute to court, the argument was already over. Not emotionally, psychologically. The decision to involve the law wasn't impulsive. It was the final step after patience had been exhausted and tolerance had quietly failed. Which is why Roman jurists didn't treat these cases as petty. They treated them as inevitable. Roman property law was not casual. Owning property meant stability, status, security, something you could pass down, rent out, or leverage socially. Property was how Romans anchored themselves in a city that was otherwise chaotic. So damage to property wasn't annoying, it was threatening. It signaled loss of control, loss of value, and loss of protection under the law, unless the law intervened. Which brings us to the part most people don't expect. This wasn't some weird edge case. Roman jurists had already thought about rainwater extensively. They understood that in cities like Rome, disputes over runoff were inevitable, so they drew a line, not based on feelings, but on consequences. You were allowed to collect rainwater. You were allowed to let it flow naturally. You were not allowed to redirect it in a way that damaged someone else's property. That distinction matters, because it meant that intention didn't matter nearly as much as effect. You could claim ignorance. You could claim convenience. You could claim you didn't think it would be a problem. The law didn't care. Damage was damage. In theory, neighbours could argue this out themselves. In practice, that rarely worked. Because once damage occurred, the dispute stopped being about cooperation and started being about responsibility. And responsibility in Rome was a legal question. This is where people stopped negotiating and started documenting. Because documentation was how you forced the system to acknowledge you. The men involved in these disputes weren't reckless. They were careful, invested, meticulous. They were the kind of people who noticed slow damage and understood what it would mean long term. Which is why these cases weren't emotional explosions. They were calculated escalations. People waited until they were certain, until they could point to harm, until the argument stopped being subjective. And once that threshold was crossed, they went to court. Once disputes like this reached the legal system, something interesting happened. They stopped being emotional. Roman jurists were not interested in who was more annoyed, who complained first, or who was being unreasonable. They weren't mediators. They were engineers of responsibility. Their job was to draw lines, not moral lines, practical ones. Because once you live in a dense city long enough, you realize something uncomfortable. People will always inconvenience each other. The law can't prevent that. What it can do is decide when inconvenience turns into harm. That distinction mattered more than anything else. Roman jurists framed rainwater disputes around one central question. Did the neighbour alter the natural flow of water in a way that caused damage? Not, was he careless? Was he rude? Did he mean well? Just, did he change something? Did it hurt someone else? If the answer was yes, responsibility followed. This was not abstract reasoning. It was a recognition that once someone modifies their property, they also modify their obligations to everyone around them. The concept of natural flow sounds simple, but it carried a lot of weight. Water that flowed naturally was considered no one's fault. Gravity did what gravity does. No one could be blamed for rain. But the moment someone redirected water, added a channel, reshaped a roof, installed a drain, the water stopped being neutral. It became intentional. And intention in Roman law didn't mean motive. It meant responsibility. If you caused the water to go somewhere new, you owned the consequences. Legal scholars like Ulpian and Paulus discussed these cases repeatedly. Not because they were rare, because they were common. They debated scenarios that feel almost painfully familiar. What if the construction was legal, but poorly designed? What if the damage was slow, not immediate? What if both properties were modified over time? These weren't philosophical puzzles. They were attempts to manage everyday friction between people who lived too close together. Roman jurists wrote opinions so future cases could follow consistent logic. This is why we still know about these disputes. Their writings were preserved, copied, and eventually collected in the Digest of Justinian centuries later, which means someone thought arguments over rainwater were important enough to teach to future lawyers. That alone should tell you how routine this problem was. Roman law sided with the homeowner whose property was damaged. If your neighbour redirected rainwater and caused harm, he was responsible for fixing it. Not apologising, not negotiating, fixing it. The law didn't care whether the neighbour thought the damage was minor. It cared whether it existed. This clarity mattered. It gave people a threshold, a point at which patience was no longer required. This legal approach did something subtle but powerful. It discouraged careless modifications. It forced people to think beyond their own property lines, and it removed the need for endless argument. Once damage was proven, the conversation ended. That's why these rules lasted. They worked. At this point, it's worth asking an uncomfortable question. Does any of this actually feel ancient? Because if you strip away the Latin, the stone walls, and the legal jargon, what you're left with is painfully familiar. Someone made a change for their own convenience. Someone else absorbed the consequences. And eventually, someone decided they were done being polite about it. That's not Roman. That's human. We like to imagine people in the past as fundamentally different, more patient, more disciplined, more stoic, and sometimes they were. But stories like this survive because they quietly destroy that illusion. The Roman homeowner dealing with rainwater damage wasn't meditating on the nature of fate. He wasn't accepting impermanence. He wasn't calmly philosophizing while his wall slowly deteriorated. He was irritated, then frustrated, then fed up, just like anyone else would be. There's a tendency to dismiss cases like this as petty. And sure, from the outside it looks small. It's water. It's a wall. No one died. No empire fell. But petty is usually just what we call problems that don't affect us. From the inside, this wasn't trivial. It was ongoing, repetitive, financially annoying in the worst possible way. The kind of problem that refuses to resolve itself and dares you to ignore it. Which is why these disputes didn't explode into violence. They simmered. This is the part that often gets overlooked. Roman law didn't exist to create order out of chaos. It existed to manage irritation. The everyday grinding friction of people living too close together, sharing walls, sharing sounds, sharing consequences. The law wasn't there to make people virtuous. It was there to make coexistence possible. Because when enough small annoyances stack up, something eventually breaks. And it's rarely the thing you expect. What makes this legal rule impressive isn't its complexity, it's its restraint. Roman jurists didn't try to legislate comfort. They didn't promise silence, dryness, or harmony. They drew one line. You can live how you want, until your choices cause damage. That's it. No moralizing. No emotional arbitration. No endless negotiation. Just responsibility. And responsibility, as it turns out, scales remarkably well across centuries. Replace the Roman roof with a modern balcony. Replace the stone wall with an apartment facade. Replace the jurist with a building administrator whose email signature includes way too many certifications. Suddenly this isn't history. It's a message in your inbox. Polite, carefully worded, sent at 7:14 in the morning. Please be advised. You know the one. We remember stories like this because they reveal something uncomfortable. That progress changes technology faster than it changes people. We build taller buildings, better drainage systems, smarter laws. But the emotional arc stays the same. Tolerance, irritation, resentment, escalation, every time. The Romans didn't invent this pattern, they just documented it. There's also something oddly reassuring about this case. The Roman homeowner didn't snap. He didn't retaliate. He didn't sabotage his neighbour. He used the system. That's not weakness. That's maturity. And it's probably why his problem still matters 2,000 years later. If you've ever Ignored a problem because it felt too small to mention. Paid for someone else's mistake because confrontation felt worse. Waited far too long to draw a boundary. Congratulations. You're not uniquely bad at life. You're just human. Same as a Roman homeowner standing under a leaking roof, wondering when tolerance quietly turned into stupidity. We don't study history to admire the past. We study it because it keeps showing up in different clothes, different cities, different materials, different terminology. Same old humans. If this story felt uncomfortably familiar, you're probably not alone. If you enjoy stories that prove people have always been like this, subscribe for more. Same old humans.